Well, hello. Welcome back to another exciting edition of Coffee with Stephen. So this week's blog is entitled New York Rifle and Pistol versus the City of New York. For those of you who've been following along at home, you know that this is the Supreme Court case that was just recently heard under oral arguments that we've all been waiting for. At least that's what all the hype has been, and candidly, I've been one of the people generating that hype. This is a very, very important case, and we're going to get the decision probably in the early springtime of this next year. Now, for those of you who aren't familiar with this particular case, I won't go into the actual merits of the case, but the reason that it's being heard, the Supreme Court had a series of cases that started with Heller versus the District of Columbia. Now, without getting into too much detail about constitutional jurisprudence, whenever there is a fundamentally enumerated right, and there's a law that's passed by a state, or the federal government for that matter, that potentially is going to damage that right, the court has a series of potential tests that they will use to determine whether or not that law is constitutionally fatal. For a specifically enumerated right, they would typically use something that would be akin to what we call strict scrutiny, meaning that there is a compelling state interest and there can be no less restrictive alternatives. If there is a compelling state interest, but you can always have a less restrictive alternative, then the law is going to fail for being unconstitutional. On the flip side, if it's not a specifically enumerated right, then they would typically use what we call a rational basis test. They would say, is there a legitimate state interest? Okay, and is the suspect law rationally related to achieving that state interest? It doesn't actually have to achieve the state interest. They just want to know whether it's rationally related to it. As a result, those laws usually are not constitutionally fatal and tend to be upheld. Well, when the District of Columbia, or Heller versus the District of Columbia, was first decided, Justice Scalia said it's a specifically enumerated right, and therefore you cannot use the rational basis test. Well, rather than appellate courts saying, oh, well, we can't use rational basis, ergo we'll use strict scrutiny, the appellate courts created a whole new test, an intermediate level of review that, surprise, surprise, you would get the same result as by doing a rational basis test. So the people or the plaintiffs in New York Rifle and Pistol versus the City of New York, they went ahead and they sued, they lost, and the Supreme Court agreed to hear the case. So all of us are looking at this thinking, well, there's a really strong probability that the court is going to articulate a more robust test, if not necessarily strict scrutiny. And in fact, both sides of the aisle kind of feel that this is probably going to be the case because a lot of Democrats in the Senate actually sent a letter to the Supreme Court saying, wow, if you even hear this case, we may consider packing the court. Okay. Now, the reason that they said that is that the state rescinded the law. After the court agreed to hear the case, the state of New York said, hey, okay, we're going to rescind the law. And because we've rescinded the law, the case is now moot. Supreme Court, you can't hear it. Well, the liberal justices on the Supreme Court seemed very fixated on, well, is this case moot? The conservative justices, led by Gorsuch, essentially said, A, it's not moot, B, we got to decide it anyways. So a lot of tea leaf readers have said, ooh, I think they're going to dismiss it for mootness. I'm not entirely sure that's the case. Anyways, read the blog. Hopefully you enjoy it. Hopefully you understand it. If you have any questions, you can always contact me at stephen@artemishq.com. As always, train constantly, train consistently, train repetitively, and train with purpose. And above all else, stay safe.